exercising her First Amendment rights, got a tainted view about whether or not this person is someone who should be targeted for arrest.
Well, respectfully, Your Honor, before he got that information and before he confirmed that she had been a protester, he asked her if she had touched the president.
Again, I asked you the question, if he saw, as you said, if he saw an assault on the president, he didn't need to ask her the question. He asked her the question because there was more information that he needed, and then she wasn't arrested for the assault. She was arrested because she didn't answer the question in a manner that he liked.
Yes, Your Honor, the arrest was for violating Section 1001. But again, if we keep the realities of what was happening in mind, what happened was he saw somebody make physical contact and he wanted to get more information about what happened.
So my question for you, and I think what all of us are trying to ask you is, your position, if I understand it correctly, is that what the arresting officer's motivation that shouldn't be a factor, correct?
That's correct.
That the reason why the plaintiffs have to allege a lack of probable cause is because we're not inquiring into the motives, correct so far?
Yes.
But can't you envision a situation, maybe this one isn't egregious enough, but think of it an example like Judge Ammon's example, or perhaps an example where the officer is motivated by racial bias or by some other kind of bias. Is it your position, and if it is, I just want to make sure I understand it, is it your position that even that kind of a situation should not be part of the inquiry?
No, Your Honor, because those would be evaluated under different amendments to the Constitution. For example,
so what
rape.
cause of action would that person have? I guess that's my question. If there's some egregious motivation for an arrest which there's objectively probable cause, is there any recourse that litigant has under your theory of how things should be?
Well, Your Honor, under our theory of how things should be, this no probable cause requirement would be applied for First Amendment retaliatory arrest violations. That leaves room for claims that people were arrested for things that are absolutely irrelevant to whether or not they should be considered absolutely irrelevant. So concerns like arresting somebody based on their race, as you brought up, that would be a retaliatory arrest violation claim that would be brought pursuant to the 14th Amendment, for example. However, when it comes...
Consider this hypothetical, which gets closer, I think, to your analysis. Assume that an incumbent Mayor Stark has instructed the police to ticket every driver with probable cause. Has a bumper sticker on his car. It says, "Dump Mayor Stark." Now, under those circumstances, there will always be probable cause. Is that a case of retaliatory arrest?
Your Honor, just to clarify, in your hypothetical, they are arresting these people.
Yes.
Well, under this court's precedent from Atwater v. City of Lago Vista, I see that my time has run, if I could briefly answer.
Go ahead.
Police officers are authorized to arrest even for what some may consider minor violations, and the court made that decision because it had to balance between different principles. And when we're looking at the realities of police and law enforcement, we always have to remember that the public welfare is on the other side of this equation. And this is a balance that the court found.
Well, in my question, Mayor Stark's welfare is at issue. And everybody who's going to be arrested for any violation with probable cause is going to be somebody with that bumper sticker on the car. Why isn't that clearly a retaliatory arrest for the expression of political views? I think you're arguing that it isn't, or that it's not actionable.
Your Honor, the only workable standard for law enforcement that can apply to all situations and to always be able to account for the policies of public safety is one that is clear, is a bright line rule, and that gives officers on-the-spot guidance about how to act.
Thank
for
you.
these reasons.
Thank you.
Thank you.
Good evening.
Good evening, Your Honors. May it please the Court. Zoe Steinberg, co-counsel for petitioners. We all know that using someone's property without an owner's permission is wrong. But that's just what Mr. Nightingale did.
Is that really your argument? The guy who just in the real world, he pays for the car. He's with his either girlfriend or wife or somebody to whom he has a close relationship. She's not in a position to give her permission because she's been arrested for touching the president or whatever. So there's no way. She clearly would have permitted him. We agree on that, right? Pretty clear that she wouldn't want to overstay her, just leave the car outside and exceed the rental car agreement. Correct so far?
Not necessarily,
So
Your
maybe
Honor.
she would be fine with that, with leaving it wherever it was, running up all kinds. Maybe. But isn't it it's just a matter of simple common sense? If the person in whose name the car is rented, if that person is not in a position to give explicit consent, but everybody knows she would have given consent, this is really something different than not having the owner's consent, isn't it?
Respectfully, though, Honor, Ms. Sparrow is not the owner of the rental vehicle.
But if she clearly had standing, correct? I mean, that's what we're talking about. If she had been the one that was stopped, we wouldn't be having this conversation, right?
Correct, because she's on the authorized rental agreement.
So if she had given explicit permission, we also wouldn't be having this conversation. Also correct?
Not correct, Your Honor.
So if she had said it's fine for you to drive it, we would not be having the conversation, right? We would be having the conversation.
We would be having the
Okay.
conversation, yes.
All right. So, but from that common sense point of view, why should we adopt your position?
Again, Your Honor, Ms. Sparrow is not the person who's entitled to give permission to use that rental vehicle. It explicitly states in Utopia Incorporated's contract that only Ms. Sparrow is authorized to drive that car.
So, counsel, your argument is that the Fourth Amendment, the right to remedy in the Fourth Amendment, should be driven by a contract, by the contract terms?
No, Your Honor, that is not what we are arguing. What we are saying, though, is that permission to be in a given place should drive whether someone has a reasonable expectation of privacy in that given place. And whether it's through, in this case, a contract, it's actually an agreement between owner and renter. Owner is giving permission through this agreement for Ms. Sparrow to drive that car.
What
So your argument is that we should reject the totality of the circumstances. In other words, Mr. Nightingale, was that his name? Mr. Sparrow. Mr. Nightingale.
Nightingale, yes.
I forget which bird. Didn't he have the agreement? Unlike I think the Fourth Circuit, I think in Welland, the plaintiff petitioners did not have the agreement, but Mr. Nightingale actually had the physical agreement. Should that have been sufficient to show that he had permission from Ms. Sparrow?
Well, Your Honor, he did have the agreement, which is a 3-page agreement that he very easily could have looked at the first line of that agreement.
Is that what
says-
people do? I mean, and you're saying it's subject to the driver reading the fine print, the Fourth Amendment remedy, subject to that?
Your Honor, it's not, as I said, contract law is not what's governing constitutional rights.
Is it your view this is just a bright line rule that if you're not the person who's on the rental contract, you have no expectation of privacy?
No, Your Honor. Although we are advocating for this bright line rule, of course there will be extraordinary life-threatening circumstances.
Like if she fainted at the wheel and he took over?
That would be an extraordinary circumstance.
That's not a bright line rule.
But, Your Honor, it's a rule that does look to the authorization of an individual to show permission. And while
The rental company would say, if your wife dies, we'll let you drive the car? I mean, is that your point?
Your Honor, we are just advocating for a more reasonable test.
Well, if you apply a totality of the circumstances test that has been invoked in some cases, do you win that test?
Mr. Nightingale would not have standing under that test, Your Honor.
So what are the other circumstances that suggest he wouldn't have standing?
Just going through the Smith factors of the
Right,
totality. So there are 5 factors that are discussed in United States versus Smith. And for example, the first factor is permission. Permission from the authorized driver. On page 3, Roman 3 of the record, it says that Ms. Sparrow was detained. She did not give Mr. Nightingale permission to drive that car.
Is it
How did
relevant
he get the
to
keys?
our thinking about that permission, that the reason why she didn't give permission was that the government was improperly detaining her? And can we consider, for example, the possibility that in those circumstances, if you ask the rental car company, if the government was improperly detaining the person who rented your car, could the person who paid for the car drive it back to get the car back to you in time? We don't know whether the rental car company would authorize that or not, do we?
Correct, Your Honor. But again, the point is that because Mr. Nightingale did not have permission from that rental car company, because there was no sort of extraordinary or life-threatening situation for him to return that car, he was only returning the car because his credit card was in the rental agreement.
What should he have
Exactly.
done?
That's the exact point, is that he has a contractual relationship with the rental car company. And having that contractual relationship with the rental car company is exactly why he should have standing, isn't it?
Respectfully, Your Honor, there was not a contractual relationship. Mr.
Paid
Knight,
for it with his credit card, right? And then when the car was not returned, it was his credit card that was charged the late fees. Isn't that not true in the record?
it is true, Your Honor. So he was motivated by
There's a
these.
contractual relationship between him and the rental car company, between him and Utopia.
His credit card was the card that did pay for
And
it.
the authorized driver would not have had to suffer any financial losses as a result of this car not being returned on time.
Correct, meaning Mr. Nightingale's incentive to return the car to not incur these late fees was his own. It
What should
wasn't.
he have done? So because we're trying to give people directions on how things should happen. So what should Mr. Nightingale have done?
He should have put his name on the rental agreement. He should have given the rental car company his license. He should.
Not what should he have done had he known that there was going to be an arrest, an unlawful arrest. What should he have done after there was an unlawful arrest to protect his financial interests based upon his rental of this vehicle?
Well, Your Honor, he very much could have driven the car back to return it, but that doesn't mean he has a reasonable expectation of privacy in that car that would give him standing.
Well,
So-
Counsel, here's my problem. Clearly, Ms. Sparrow had a reasonable expectation of privacy. And I'm picturing Mr. Nightingale that night. He's with this person he knows well. He's trying to do the right thing. He's not thinking, boy, I wished I'd put my name on that rental agreement. That's probably the last thing in his mind. So why are we going to say he doesn't have a reasonable expectation, but Ms. Sparrow would have? Why make that kind of distinction if this is an important interest of a citizen?
Because, Your Honor, it weighs on the fact that Mr. Nightingale simply did not have permission to be in that car from the owner. And
He didn't have express, but I think almost anybody in this room would have thought under those circumstances, I bet Miss Sparrow is mighty glad I'm taking this car and turning it in before we get charged with keeping a car we're not supposed to have.
Your Honor, the standard to determine a reasonable expectation of privacy doesn't only hinge on a subjective expectation, and that's what this court discussed in Raucus versus Illinois. It also hinges on an objective expectation, saying that an individual's reasonable expectation is reasonable, and society would deem it to be reasonable.
Well,
So-
I think there are a lot of people that would say that's an inherently reasonable man who decided to do what he did and didn't stop and say, oh, boy, I didn't put my name on that rental agreement. Good luck, Miss Sparrow.
Well, Your Honor, again, there are the facts in this record that do weigh in the fact that Mr. Nightingale would not have that expectation. And again, not having permission from an owner really does weigh very heavily to the objective standard.
Would your argument be different if she had been in the car with him? Would he have had a reasonable expectation of privacy had she been with him?
if he was driving or as the passenger?
If he's driving, would he have had a reasonable expectation of privacy if she had been with him?
No, Your Honor, because again, Ms. Sparrow doesn't have the authorization.
But she would have been presumably consenting at that point in time to let him drive, right?
Presumably, maybe, yes. But again, she doesn't have that authority. And to be able to have this bright line rule that looks just to whether an individual has permission from the owner is far more applicable or far more administrable by law enforcement agents who are just trying to protect public safety.
Well, excuse me, doesn't your rule say that police officers could stop every vehicle, see first instant, is it a rental vehicle? Second instant, who's driving, who signed the rental agreement? And if that driver had not signed it, then they can search that car with or without any grounds because that person is deemed to have no protectable rights. Is that what you're arguing for?
Your Honor, what I'm arguing for is that when an officer sees a rental agreement, when they ask for license and rental agreement, the license doesn't match the rental agreement, that's automatically going to trigger that person might be a thief, that person might have stolen the car, especially in this context with the heightened security around President Saxon's rally.
Well, you're arguing for a really general proposition that without authorization, somebody cannot really have an expectation of privacy. And we're dealing with a very complicated fact situation. Take a simple one. What about a teenager with a driver's license who drives the family car without permission? You know, that happens.
Yes, Your Honor, it does happen.
And does that person have an expectation of privacy in the family car?
Well, Your Honor, they shouldn't unless the rental car company sees their license.
I'm not talking about a rental car. I'm talking about the family car, mom and dad.
Well,
Kid takes it.
Well, if mom and dad own the car,
Yes, they
they're
do.
the owners of the car.
And they didn't
therefore,
give permission.
They
So-
did not give permission.
And therefore, under your analysis, the kid who's driving it has no expectation of privacy in that car.
Your Honor, I'm referring to the very narrow rental car context where the only way that these rental car companies give permission to drivers is through that
The
agreement.
operative principle when you deal with the rent-a-car agreement is authorization. That's the legal principle that draws the line that you're not willing, that you think is bright.
Yes, it's the authorization and a person inhabiting some sort of property with the owner's permission. So while there are circumstances where a parent might not have given their child permission, that's outside the scope of this very narrow context of rental cars.
Well, you know, these principles have other ramifications. I mean, what about a person who taps into his neighbor's Wi-Fi? Does that person have an expectation of privacy in their internet searches?
Your Honor, whether or not they do or not, this is in the rental car automobile context where this court has acknowledged that
Well,
cars...
I mean, why would we decide a major constitutional question involving interpretation of a rental car contract? That's getting very close to one of the early questions we asked, which is, are we enforcing rent-a-car contracts, or are we enforcing the Fourth Amendment?
Well, Your Honor, first of all, you would be enforcing the Fourth Amendment, and that's with permission. But the reason why this is so important in the rental car context is the rental car industry is growing. People use zip cars. They rent cars on a daily basis to be able to go
They also
to...
lease them by the year, and 3 years or 4 years. And members of the family don't have an expectation of privacy if they take the car and they weren't on the lease agreement?
Your Honors, I see that my time has run. May I briefly answer
Fine,
and
please
conclude?
do.
Just to restate your question, that if they were not on the lease agreement, if a family were to give or not to give permission to an individual, why would that be any different than in a rental car context? Is that me
Yeah, that's the
understanding?
question.
It's because in this narrow context, as I said, the only way that permission is given is through that rental agreement. And I do understand that families or parents may share their cars, but it's the owner, the rental car companies, who don't have any sort of relationship with the people who are taking their cars. Commonly, rental cars are used for criminal purposes. If you're a family member, you at least know that individual who or presumably know that individual who is taking the car.
Thank you.
Thank you.
Good evening.
Good evening. Mr. Chief Justice, and may it please the court, my name is Taylor Mullaney, and I represent the respondents in this case, Ms. Sally Sparrow and Mr. Larry Nightingale. I will discuss the First Amendment issue with your honors this evening, while my co-counsel, L.J. Pavletic, will discuss the Fourth Amendment issue. Your honors, this court should affirm the decision of the 14th Circuit Court of Appeals and refuse to impose a no probable cause standard for plaintiffs in retaliatory arrest cases.
Wouldn't we, though, if we affirm the decision of the circuit, wouldn't we be opening up floodgates of in each and every arrest, the arrestee complaining that his or her First Amendment rights were violated?
No, Your Honor, and here's why. So, first of all, in the 9th and 10th circuits, we currently see respondents' rule operating. We've seen that for almost 10 years now, around since Hartman versus Moore in 2006. We do not see that floodgate of litigation occurring there. Furthermore, we're actually talking about a narrow subset of cases here, where there is protected speech that is not contested on either side here, and then there's an arrest. So there's only actually an average of about 100 cases, 86 to 100 cases in the last 10 years per circuit.
Isn't it possible that in those jurisdictions, the police find it very risky to arrest people who are protesting unless they are marching in support of the police?
Not necessarily, Your Honor, because we have seen no evidence, no real scholarship about that in the 9th and 10th jurisdictions or the 14th. The issue here is that in these cases, as we see them brought to this court time and time again, what we consistently see is very weak evidence of probable cause alongside very strong evidence of potential retaliatory animus. The first reason that we want to be sure that you adopt respondents' rule today is because not doing so would be an unmerited departure from this court's typical retaliation jurisprudence. And though this court has carved out narrow exceptions to that standard over time, none of its reasons for doing so apply in the context of retaliatory arrests.
That these cases often involve weak probable cause. What if there's a case where there's strong probable cause?
Certainly, Your Honor. Looking to the idea of the probative value of probable cause, what I was just referring to earlier is, of course, Hartman versus Moore, this court's 2006 decision, where you said that retaliatory prosecutions are unique. They're unique for 3 reasons: attenuated causation, probative value of probable cause, which I'll address, and the discretion that we accord to prosecutors. So looking to the probative value of probable cause, we can imagine a situation in which someone is walking down the street, they exercise their First Amendment rights, they say, "I hate the president," and then they hold a gun to someone's head. Then they're arrested. In that case, the probable cause for the arrest is going to have extraordinary probative value. However, say we imagine the same scenario where someone is exercising their First Amendment free speech rights, and then they fail to, say, use a crosswalk, and they're arrested. In that case, the officer still has probable cause. And importantly, petitioner has conceded that there are cases where officers can have probable cause but be motivated by something that is not legitimate. This is extremely concerning here today, Your Honors, because what they're essentially saying is that there can be these unconstitutional grounds for arrest, and then plaintiffs like my client and other plaintiffs similarly situated have no avenue at law for a remedy. So importantly, what we're asking of you is not that she receive a remedy at law, but rather that she have an avenue through which to seek one.
But what does it say about law enforcement? How are they to conduct themselves if they sort of have to sort of navigate this very technical legal question in order to decide whether they ought to arrest the person?
Certainly, Your Honor. I think the Mount Healthy framework is especially useful here. So we can see that under Mount Healthy, Ms. Sparrow would have to plead and prove that there was constitutionally protected conduct. We know that there was, neither side contests that, and that it was a motivating factor in her arrest. At that point, and only at that point, would the burden shift over to the police in this case to show that they would have taken the same action in the absence of that constitutionally protected conduct. Now, 2 more points to Your Honor's question. The petitioners bring up this idea of public safety. Of course, we're concerned with public safety. Police officers are charged with that. They have to be able to do their jobs. These cases, as we see them brought, are not ultimately about public safety. They're often about small, sort of technical violations of the law alongside very potentially unconstitutional motivations of arrest.
So is that what we should be looking at? I mean, that's not the case in all of the, if there's a protest or where people become violent quickly, I mean, it's very easy to see a situation in where somebody could claim, make this very claim in a protest situation, and that's, I mean, law enforcement has a fine line to walk there. So isn't that precisely the context that they could be very worried about something like this, that not entirely sure how to operate?
Not necessarily, Your Honor, and the facts of this case speak directly to that. So if this case had been different, say if it had brought into play true threats or incitement to crime or sort of these areas of First Amendment jurisprudence in which we're willing to say, okay, we're going to curtail some First Amendment rights in order to uphold public safety, we might be looking at a different case. We also might be looking at a different case if police officers had arrested Ms. Sparrow after she rebuffed the president's advances, but they did not. And we know from the record, bottom of pages 2 and 3, that these are police officers who specifically requested assignment at this rally because they are avid supporters of this president and of his cause.
Why shouldn't we consider that allowing probable cause to block a claim for retaliatory arrest will have all kinds of desirable consequences? It'll encourage civil discourse, orderly protest without damage to property, without people spitting in each other's faces, grabbing their signs and hitting each other over the head. Wouldn't it be a better environment for the First Amendment and for everybody if you lose?
No, Your Honor, it would not. Ultimately, these plaintiffs' First Amendment rights are going to be chilled if they are booked and taken to jail in retaliation for their speech. And the issue here is that these plaintiffs are going to be able to be arrested in retaliation for their speech if you issue a rule like that which petitioner wants today. The issue here is that as we see these cases brought, we constantly see people arrested for things like videotaping police officers, documenting protests, say failing to use a crosswalk, holding an object that's a few centimeters too large while protesting. This is an even bigger concern in the digital age as we see more and more courts saying that videotaping officers, documenting protests are actions
that is a separate issue. The videotaping of the police as a First Amendment issue, it's unsettled, but it's being heavily litigated. So I'm not really sure that that's something that's before us or that we are in a position to decide.
You're correct, Your Honor. The circuits that have addressed it have said it does fall under the First Amendment, but it's certainly still an open question. So take, for example, another case where a plaintiff was in the position where they said they were going to file a report with a police chief. Okay, and then she was arrested, supposedly for battery because she slapped that police officer's hand away, not in an aggressive way, in a light way. This is another case that came before a district court. These are the kinds of cases we see constantly in retaliation for protected speech, and it's extremely problematic. And Your Honors, if you're
You wouldn't think somebody would expect to be arrested if they're slapping the police officer's hands?
So, Your Honor, in that specific case, it was an officer who, in the factual record, had his hand out like this to her, and she just pushed it aside. It was not an actual intensive battery.
Pointing.
That's the very issue, though, is that we have to engage in these factual inquiries. We have to bring these questions before juries. And to Your Honors, Justice Donnelly and Justice James's points, the issue of public safety is one that is so important, but that's one that juries can look back at these cases and they can make the judgment that, okay, police did not actually take that action, or police would have taken that action in the absence of constitutionally protected conduct, or they would not have.
Can we solve the concern that you're identifying by asking the question whether there was probable cause with significant rigor? That is, some of the examples you give seem to be ones where, as you said, there are weak cases on probable cause, and I understand that. let's suppose that the cases are not weak. You don't dispute that if there is legitimate probable cause, or do you dispute that it would be incongruous if there is legitimate probable cause to say, for example, this police officer can perform this arrest because this officer is not offended by the offensive things that the plaintiff has said. But since this officer is offended, the same arrest can't take place.
Your Honor, that question speaks directly to the current test adopted by the Ninth Circuit, which is a little unique, and Your Honors could choose to adopt a test a bit like it. So they have carved out an exception in the Ninth Circuit for cases with particularly attenuated causation and for egregious felonies. So that, like which Your Honor is describing, if there are egregious felonies, the Ninth Circuit says, okay, we will go ahead and impose a no probable cause rule on those plaintiffs. And if there's attenuated causation, the examples they have are things like, say, there's animus in June, and then there's an arrest 6 months later. Or there's a group of 20 officers, some of whom have animus, and some of whom end up arresting the person. Those are examples of attenuated causation and felonies for which we might be willing to impose a no probable cause requirement. But Ms. Sparrow's case, and most cases, frankly, that are brought before district courts in this country, do not fall under that.
A quick question. If the plaintiff does not have to allege and prove the absence of probable cause, does the defendant then, the defending officer then get to put on a whole case in the defense of the trial about, I'm accused of having animus, but look at all this probable cause, look at all of this reasons that I acted? Does the defendant still get to do that in your view of these trials?
Under Mount Healthy, not necessarily, Your Honor, but they would get to bring forth evidence. And the idea here is that if they are bringing forth evidence, that they would have taken the same action in the absence of constitutionally protected speech. Again, this is a narrow subset of cases, then they're going to be fine. These police officers are not going to have an onerous burden placed upon them such that they cannot act in the field each day.
Well, in the trial, is that going to be phrased in terms of before the jury of did he or she have probable cause or not, rather than just all these other, I mean, are they going to use that test of was there or was there not probable cause?
So it's an inquiry that would be engaged in first in the prima facie stage of the case, so there may actually, frankly, be summary judgment in favor of officers sometimes. And then once it does get to the trial phase, Your Honor, that's a point at which we could engage in that inquiry. Probable cause, would not, it's not dispositive of a proper constitutional arrest, but still, juries would be able to make decisions whether there is or is not probable cause there.
But you're putting the burden there on the defendant. The defendant has to show that probable cause was the substantial reason. I mean, if there's any question at all about maybe the jury thinking maybe there could have been some concern the officer had for the speech, now you're placing the burden entirely on the officers to prove that they had good intentions. Is that the kind of test that we want?
No, Your Honor, the burden wouldn't be entirely on officers to prove that they had good intentions. It's simply that they would have taken the same action in the absence of constitutionally protected conduct. It's all about this nexus between that constitutionally protected conduct and the arrest. And we don't want the conduct driving the arrest. Pardon me.
Now here the arrest isn't for slapping president. The arrest is for lying to the officers. And I'd be interested to hear your drawing a line between the probable cause and this arrest with respect to lying, as opposed to all the examples you gave, which were really talking about whether or not there was an assault or some other clearly observed of crime.
Your Honor, we know from the record, pages 2 and 3, that it is only when Officer Ricky Toclafane realizes that this is the vocal protester from the front of the stage that Lucy recognized because she was vocally protesting. It's only then that he asks her another question and detains her. It's only when he gets confirmation from Officer Lucy Toclafane that she is in fact that protester that he arrests her. This speech comes up 3 distinct times in the record, each of those times with a very strong causal nexus
between the speech and the animus there. And we want to make sure that these are the kinds of cases that are coming before this court. This court has said that the First Amendment embodies a profound national commitment to the principle that debate on public issues be robust, uninhibited, and wide open.
Well, that's accepted, but say cannot an officer or a set of officers, a set of troopers, use their, I mean, you have several officers there, so they all have different sets of eyes and ears and can put together different sets of facts. Say one officer saw a person enter, took note of a person entering a room wearing all black with a bulge in his clothing, and then another officer stops that person separately. Can't they then at some point put two and two together and make a group determination about whether or not there's probable cause? One officer sees one thing, another officer sees another set of facts, and when put together, maybe they have probable cause, when maybe separately they didn't have probable cause.
Your Honor, I see that my time has expired. May I be permitted a moment to respond?
Please answer the question.
Certainly. Yes, Your Honor, they could do that. Certainly we want officers doing that in these cases. That's not what we see happening here. We see that both of these officers had the same retaliatory animus, that both of these officers made the arrest, and that is exactly what's going to ultimately chill and inhibit speech and give police officers carte blanche to point to any probable cause in the universe, even if it's pretextual. That's the issue here, and that's why these plaintiffs must be able to at least air their grievances before this court. For all these reasons, we ask that you side the 14th Circuit. Thank you very much.
Good evening.
Mr. Chief Justice, and may it please the court. L.J. Pavletic, continuing argument for respondents. I will be discussing the question of standing under the Fourth Amendment. The petitioners mistakenly attributed the three tests at play here to police officers and the decisions they have to make in the field during the heat of a search. These three tests are not for police officers to apply in the field to determine whether they have probable cause or not.
But what are the police supposed to think? I mean, they don't know that, whatever that lady's name is, the other Miss Sparrow. They don't know that she's back at the precinct. All they know is that they stop a car and that this guy does not, he's not the name on the rental agreement. What are they supposed to do? How are they supposed to, maybe he's lying.
Frankly, Your Honor, that is exactly what the police are supposed to do, which is apply the standard of probable cause.
But how do they know he's got how do they know he's got standing?
Standing is not a question for the police officers to apply in the field. Standing is an ex post question for courts to apply months after the search in question happens. Probable cause is an ex ante determination that police officers are concerned with. The facts.
So if that's the case, then why are we having an argument about the probable cause of the police officers in making this arrest? They made a stop. They have a uniform method for making the stop, and when they make the stop, what they find is that they have a person who has apparently no basis for driving this particular vehicle. The question before the court is whether that particular person, who then was found in possession of some unlawful item, whether that person has standing. That's your burden, is to have us understand why that person, under those circumstances, is entitled to argue standing, not whether police officers need to, not how police officers should conduct their business. What you need to be focusing on is the question of, is there standing under the circumstances here, and what standard we should take in finding that, or answering that question.
Your Honor is exactly correct, and that is my point here. Petitioners make the argument that the totality test is not a good fit because police officers are not able to apply and ascertain these multiple factors in the field. But that's just simply not the case. Courts are the ones who apply the multiple factors post hoc, months later in a suppression hearing. And that's what courts do all the time in these kinds of cases, and they're particularly well situated to do so in balancing the factors and interests at play. All police officers have to do is what they have always done, which is evaluate whether there's probable cause to conduct a search.
So let me go post hoc with you for a second. If I'm a rental car company, every rental car company you've ever dealt with needs to see your license before it authorizes you to drive one of its rental cars. Is that right?
Correct, Your Honor.
And rental car companies, for example, typically if more than one person is going to be driving the car, they want to see all the licenses of everybody who's driving the car, and will frequently charge more money if there's more than one person driving the car, right?
Correct again, Your Honor.
So you don't dispute that there is absolutely no way in any sense that this rental car company has any kind of contractual understanding that this guy could drive this car without having shown his license and been approved, put in a contract, and possibly having paid extra money for the privilege of being an additional driver, in addition to the designated one. Is that right?
Correct, Your Honor. To Your Honor's point, my client here is in violation of the contract, but the
He's
contract...
got no permission, right?
That is not true, Your Honor. He might have not gotten express permission from the owner of the rental vehicle, the rental car company in this case, but he did have permission, implied permission, from Ms. Sparrow.
Well, she has no legal authority to give the rental car companies permission to drive the rental car company's car, though, does she?
That's not quite true, Your Honor, because as this court has recognized in Jones and Olson, those are the two cases that deal with overnight guests in a friend's home. In those cases, the person who lived in the home, or answered the door to the police, rather, did not legally own or possess the space.
Of course, in those cases, the visitor, guest, clearly had the owner's permission, right, to be in that very fixed space.
And same here, Your Honor. The police go through the same inquiry when they're knocking on the door at their home to ascertain whether that person has permission or not, and they undertake a credibility determination. This is the discretion we give police officers.
But they don't have permission from the owner. They have permission from somebody who herself has permission from the owner. But does that automatically give her, she can lend this car to anybody, and that person now has standing to contest the a stop of the car?
The totality test gets at the nexus that the individual has with the space, here at the rental car vehicle. And permission is not the only factor that the 6th and the 14th Circuits look at. So permission is one factor, but there are others. Mr. Nightingale was a licensed driver. He was able to present the rental agreement to the law enforcement officer and provide her with information about the vehicle. He also had a long-standing personal relationship with Ms. Sparrow. And most importantly, as the 6th Circuit recognized as the most important factor in Smith, he had a business relationship with the rental car company. He both paid for and reserved the rental car. That establishes his connection to the vehicle. That is the nexus that gives him standing to challenge the search.
If he gave the money to Ms. Sparrow and she rented the car, would he be in a business relationship with the rental car company? Surely not.
If he gave Ms. Sparrow an envelope of cash. And
yes, and she rented the car.
Maybe
and all he did is he gave her his credit card.
That's
basically he has a relationship with her, and she has a relationship with the rent-a-car company.
That's not quite correct, Your Honor. He has a personal relationship with her, but he also has a business relationship with the rental car company because, as the record shows, he went online to book the rental and he used his credit card through an online portal to make that reservation. So it's not 2 degrees of removal. He did have a one-to-one relationship.
Was the reservation in his name?
I'm sorry, Your Honor, that escapes me at the moment. She was the only authorized driver, so presumably
his address on the rental agreement.
His address was not on the rental agreement.
If I make a reservation for 2 people to have dinner and 2 other people show up with my permission, do I have, and I don't eat, what kind of relationship do I have with a restaurant? It's just making a reservation.
I'm sorry, Your Honor, I didn't catch
This is
that.
making a reservation. He
Correct.
didn't follow through on it. She did.
Correct, Your Honor, but again, in the hypothetical you just posed, that presumes that he doesn't pay for the dinner and he doesn't show up. Here, he did show up. He ended up driving the rental car, and he did pay for the rental car, and he did follow through on that reservation. He attended the rally with Ms. Sparrow. Now, respondents contend that the totality test is the best test for this court to apply. It is the test that the court below adopted, and this court can affirm on those grounds.
Mr. Pavletic, may I ask this question? Are you saying that the police officer, if we adopt your test, doesn't have to go through this totality of circumstances analysis there on the spot, that this is not going to affect anything about what he's doing? If he's got probable cause, he makes the arrest, and he's not going to be subject to liability, or he's not going to be sued. Is he supposed to go through the totality of circumstances test?
He is not, Your Honor. Courts decide standing as questions of law. Police officers decide probable cause. Now, to be sure, after this court announces a rule, I imagine that that rule will inform police officers' conduct down the road. But that's not until this court announces a rule.
Yeah, we have to assume he or she's going to want to make a valid arrest. I mean, I like to think that's what they're trying to do. And if he knows there's some court that said, well, we're going to apply the totality of circumstances, how's he going to be educated? I mean, is he going to interrogate every driver who's not on the license agreement and say, we got this thing called the totality of circumstances, so now I got to know everything about how you got there, who rented this vehicle, where is she, why are you driving it? Is that what he's supposed to do before he moves forward in order to make a valid arrest?
And yeah, how does the state of, was it trafficant? How does the state of trafficant teach its officers so that it's not violating, their officers are not violating the Fourth Amendment?
Well, the officer conducts this court's totality of the circumstances test as set forth in Illinois v. Gates to establish whether there is probable cause or not. And the factual scenarios that Your Honor—
I thought you said that that was for a post hoc evaluation by the court.
No, Your Honor. So this court under the Fourth Amendment issues two kinds of rules: decisional rules and conduct rules. A decisional rule is standing. It is a pure question of law that courts apply post hoc.
So the question is, I think the question is that that police officers have no reason to fear this rule, because even if it turns out that the person has standing, because presumably we want police officers not to, standing is a right, so we want police officers to respect that. So I think the question that, certainly that I have, is what are they supposed to do with this? I mean, let's say that we come down with this ruling that, and the cop has no reason to know about these connections. What investigation are they required to do? None? All right, is it just fine? Even though we announce this rule of standing, do the police not have to be aware of that? Is that your position? Because courts make the decision. I'm not going to say it in Latin, but because courts make the decision that the police have nothing to fear. Is that what you're saying?
No, Your Honor. Obviously, Mr. Nightingale would encourage police officers to be accustomed with these rules. However,
with all the rules, so they should try to figure out that he's got a girlfriend who was arrested, who's and they'd have to accept that, or would they have to then call the precinct to see if she's there? And what exactly are they supposed to do?
This is what police officers do at the traffic.
I don't think so. I don't think they conduct a whole investigation to determine what the person's connection to the car is. Maybe they do. Well, is that what you want them to do, though?
What happened in the record here, I think, was perfectly fine. There was a traffic checkpoint to stop drunk driving after this presidential rally. And the police officer inspected the license. The police officer, Mr. Nightingale, handed over the rental agreement. The police officer was inspecting the rental agreement, and then—
That he's not on.
Correct. And this all goes to probable cause. So if he's not on the rental agreement, that might encourage the police officer to ask the individual a few questions. How did you get this rental car?
Do you have to believe what he says?
The police officer has to make a credibility determination, just like the police officers did in Jones and Olson when they approached homes and those people told them they had permission to be there because the owner or renter owned that space.
We're in the context of a Section 1983 case, so we can't do, it doesn't seem, we can't do a post hoc standard for the courts and a separate standard for the police, because what you're saying is if the police make the wrong decision about searching the vehicle without evaluating standing, then the city is going to be liable for monetary damages under Section 1983. So we can't have separate standards for what the police need to do on the field and what a court decides with respect to standing later on. Either the officer can look at a rental agreement and see that there's a disconnect between the authorized driver and the person who presents the license, and if there is, then it seems that the officer ought to be able to say that, well, there's some suspicion here, because we have someone who, normally the case is it's, let me see your license and registration. Well, in this case, the registration substitute is the rental agreement, and the rental agreement doesn't show this person who's driving the car to be an authorized driver. That's suspicious. That's a reason for the officer to conduct further inquiries, and you can't do an inquiry of, well, does your girlfriend rent this car, and what happens to your girlfriend, all those things. None of those things can be done effectively in the field if they're trying to stop every third car on a drunk driving stop, or whatever you call it.
Your Honor, the facts go to both questions. So the same set of facts go to the threshold determination, which under petitioner's rule, my client is barred at the courthouse doors. He does not even have a claim, a Fourth Amendment claim under Section 1983, because under their rule, he does not have a reasonable expectation of privacy. If you accept
Counsel, let me just ask, are we agreed that as the rules stand, if the person driving the car has standing or reasonable expectation of privacy, then the police can't search without probable cause? If the person driving the car has no reasonable expectation of privacy, no standing, police do not need probable cause. They can search the car willy-nilly as much as they want, no probable cause needed, correct?
Correct. Mr. Chief Justice, with permission, I'll respond.
Please do.
So don't police have to be able to make the standing requirement to be able to answer right there on the spot, make the standing assessment so that they can determine whether they need probable cause to proceed?
Your Honor, this is exactly the problem with petitioner's rule. Under petitioner's rule, the warrant requirement has already been dissipated with under the automobile exception. All respondents are asking this court to do is hold the government to probable cause. Under their rule, the police do not need probable cause to conduct a search. They can search the vehicle without a scent of wrongdoing or suspicion. The Constitution guarantees my client more. Thank you.
Thank you. We'll hear rebuttal. Go right ahead.
Your Honors, this case is not about sitting in a courtroom, looking back, and trying to decide what should or should not have happened. Your Honor, this case is about crafting rules that work for gritty, snap judgment, highly emotionally and politically charged situations, when officers and law enforcement officials are tasked with either protecting the public welfare, or in this case, protecting the newly elected President of the United States. Your Honor,
What's the protection for the newly elected president? As I understand, the car was going away from the rally.
well, Your Honor, in that situation, it's important to pull back and remember that what the officer saw was a car whose registration on the rental agreement didn't match the person who was driving it and had a partially concealed gun there. Now, in that situation, the police officer was looking at this, and she had to decide whether she was looking at simply an easy mistake or potentially the next mass shooting attempt. As for the First Amendment issue, Officer Ricky Toclafane had to look at Ms. Sparrow and try
Well,
to
doesn't the argument you've just made obviate all of the other arguments you're making? Because if the officer sees a partially concealed gun in plain view, that's probable cause to search the car right there. Or what are we all talking about this
Your
evening?
Honor, the plain view exception is certainly an issue, but the issue on appeal is in these snap judgment scenarios.
No, I know, but you're the one who mentioned the concealed gun.
Your Honor, the reason that I mention it is because it illustrates how snap judgment these kinds of decisions need to be. In these situations, this court has always held that police officers need the clear guidelines and the clear guidance of bright line rules. Thank you.
Thank you. Thank you all. We will reserve decision.
These do we go?
Okay, wait 1 second. I did put it on video. Here we go. 1, 2, 3. Okay. I got them at first. We're very happy with how this round went.
I'm gonna go, I have to go just see if. Pictures, okay.
Oh, sure.
Yep. Okay. Get in there for a picture? Oh, sweet. Okay, great. Very much. Get one of you two.
Rick.
No, just put a little space in between. Yes. Here. You know what, let me, now you can get together. I'm a little bit just to the side, yeah, that's good. I'll tell you in a minute.
Watching now.
You know, Mom,
Tell her I say hello.
So something made it further, but I don't get that done. There's nobody better than Brian. You know, I've just kind of never come, I've never invited, but I think it's the first time they say, I don't find that. Usually I never go follow up. is an officer's counsel? It's not a big deal. So it's very proper. So Ms. Deborah, next time Ms. Deborah, what about? That's why I think the best argument. Yeah, what if it's yeah, yeah. Your daughter is excellent. And saying you do trust. She said to come back to what you said. Well, no, you can't. You're not as judges. You're not supposed to do that, right? You don't just freeze on the spot.
What is to look at them like? But the whole world is watching. You know, it's kind of a way.
Please be seated. I'm sitting in the wrong chair.
You know who you are.
Somebody has switched my chair.
Good trick.
So I'm going to stand up as I preside. What is the next step in the program? Oh, well, there's not much left to say when, as judges, we match wits with 4 last oralists left standing after all these rounds. But it must be said that the arguments tonight evidenced the intense preparation and the deep study that you have all done. It showed in the only way it is ever really evidenced, and that is by the relaxed and confident advocacy, lively and courteous interest in what the judges need to know and are asking, and the ability to contend with 7 judges coming at you. So we applaud this group, and we leave the room tonight with real admiration. We wish you, one and all, great good fortune and fulfillment in your very promising careers. Thank you.
Thank you very much. Once again, my name is Daniel Rothschild, co-chair of Moot Court Competition with Byron Huang, my co-chair. We're going to start the awards ceremony at this point. We know that you're seeking a bit of information about the outcome. That'll be forthcoming, don't worry. First, I want to offer everyone a round of applause for tonight's final round. Excellent job. We also want to express our appreciation for the judges here tonight. Thank you for your serving us. Thank you. Mr. Franklin, may I ask you to come down to present the awards? We're going to start with the Best Brief Award, and we wish to congratulate the University of, we wish to congratulate for the runner-up Best Brief, the University of Washington, if you're here. For the Harris Tweed Award for the Best Brief goes to University of Iowa College of Law. We understand that name in here. Now for the individual awards. The first award is presented to the runner-up individual speaker, and that is for tonight's round. That's awarded to L.J. Pavletic from Northwestern University. The award for Best Individual Speaker goes to Taylor Mullaney from Northwestern University. At this time, Mr. Chief Justice, would you please announce the verdict of the court?
The winner of the round, and therefore the winner of this competition, is the team of respondents, and there is no reversal on the brief.
Congratulations to Northwestern. We first wish to congratulate the runner-up best overall team, and that's awarded to the University of Southern California. Rachel Young, Zoe Steinberg, Rebecca Lonnie. The John W. Davis Award is given in memory of John W. Davis, who's a former president of the American College. That award is given to the team presenting the best oral argument, and then the final rounds, of course, that winner is Northwestern University, Taylor Mullaney, L.J. Pavletic, Brendan Gerdes, and with the coach, Sarah Schrupp. You can come and accept that. All right. Once again, congratulations to to both teams. A big thank you. We look forward to your participation in the National Moot Court Competition, the 69th. That'll happen starting later this year in September when the problem comes out. And we, again, thank all of you. Please gather around for pictures with the judges. Have a great evening. Thank you.